Okay, so we're on 19b towards the bottom. Let's see about 7 lines up. 1, 2, 3, 4, 5, 6, 7, 9 lines up. Okay. We've been talking about testimony that contradicts previous testimony. So here we have a case of two people who signed a document and they died, so they can't testify as to their own. If the contract is challenged, their signatures are challenged. They're not there to support, to testify that this is indeed their signatures. So two other people come and they say, we recognize this is their testimony. But we also know that when they signed this document, they were compelled to sign it. They were forced to sign it. Someone threatened them and said, as in the famous Godfather scene, either your brains or your signature will be on this document in 5 minutes. So the signatures are real, but they're not valid. Or they say Ketayim Haru, they were this is their signatures, but they were 10 years old, and they were not valid. They were not eligible to sign, or psulei hayu, or for some other reason, there are various reasons that a person is disqualified from testifying, and therefore also disqualified from signing a document. So it's their true signature, but at the same time they're not eligible to sign. So we believe them because we believe both sides of their testimony, right? It's kind of like hapeshasar hu hapeshahiter. Either you're going to believe them or not believe them. If you're going to believe them, then you're going to believe that the witnesses who signed were not eligible. But if there are two other witnesses who certify their signatures, and they don't say the other part, that they were forced or they were otherwise ineligible, or it doesn't have to be witnesses, but could be some other way of verifying their signature, compared to a notarized document. Or a mishtar shakar of which would be from a document that had been challenged and certified in court. So in other words, independently of these witnesses that are testifying that the signature is true, but the signatures are ineligible, or the witnesses were ineligible, the signers were ineligible, then we don't believe those two witnesses, because we have another source that certifies the signature and doesn't disqualify the witnesses, the signers. Okay, that makes sense. And no, so that's the Gemara's statement. Now the Gemara is asking, what? So you have this document and you can use this as a valid contract. In other words, to collect or to enforce the terms of the contract. Wait a minute. Why don't you say that it's 2 versus 2? So you have one set of witnesses that certify the signature and say that the document is valid, and another set of witnesses that say the document is invalid for the reason, whatever the disqualifying reason was. So why isn't it 2 versus 2? and we don't rule like one versus the other. Amar of Sheshes, so this tells us that what are we using as kind of the model for this? It's like literally the beginning of Hazama. In other words, this resembles Hazama. What does Hazama or Eidim Zoma mean? Usually, every set of witnesses has equal validity, assuming that they're not disqualified. Okay, but if witnesses testify to something, and another set of witnesses come along and say that can't be true because you were not there, we were with you in Tel Aviv when you say that you witnessed something in Jerusalem, then we believe the second set. Okay, and that is a unique case discussed by set down in the Torah where you do believe the second set of witnesses that contradict the first. Not that they're contradicting the testimony directly, but they're contradicting, um, you know, the ability of the witnesses to be telling the truth. So that's hazama. So our case where you're testifying, where you have 2 versus 2. So he's saying, like, it looks like, if we believe the second set of witnesses, that we're kind of following the model of Edim Zon. And the Gemara is going to reject this, by the way. It it doesn't, like, we're taking the unique properties of Hazama, we're taking it too far. So, but let's just follow this thread. Just as you can only do Hazama in the presence of the witnesses that you're challenging, that it only works in their presence. If they're not present, but you are, they've given their testimony, they've gone home, and then you come and say, wait, those 2 witnesses couldn't have been telling the truth because we were with them somewhere else at the time. So the same thing would have to apply with hakasha, with just contradicting their testimony directly, and then in our case where they've died, right? Remember, the case that we're talking about is where the original 2 witnesses have died. Obviously, you can't testify in their presence because they're dead. Therefore, that's why their testimony is now ironclad. They can't be challenged because they're dead, and so the document is therefore considered enforced, considered valid. Okay, but as I said, we're going to reject this. Let's say they were alive, okay, and then the second witnesses, and they were here in court, and then the second set of witnesses came and said, no, that's not true. What you're saying is not true. Then we would disregard the testimony of the signers because it's been, in other words, then we would have the 2 versus 2 thing again. We wouldn't give more credence to the ones who said it's valid. So now they're not here, they're dead. So that we can say that, if they were here in person, then maybe they would say, like, if they were here, they might retract their testimony in the face of contradicting testimony. But now they're not here. We're saying, like, it's stronger because they're not here. That makes no sense, right? Okay, so why is it, says Rav Nachman, that we don't believe the second set of witnesses? It's not that we believe one over the other. It's that we leave things the way they are, the status quo. Okay, so we're not going to confiscate or to enforce the terms of a contract actively if we have contradicting testimony. It's not a question of we believe one more than the other. We're just going to leave things the way they are. Okay, that makes sense. And here's a supporting story. It's like the case of the property of this guy Bar Shatya. Excuse me. The Bar Shatya Zavin, he stole some land. The 2 witnesses came to say he was deranged, he was insane when he sold the property. The transaction is not valid. And 2 others came and said, no, he was perfectly sane, he was normal when he sold the property, and it is valid. So what do you do? Said Rav Ashi, leave things as they are. It was his before. There's 2 contradicting sets of testimony that whether he sold it or not. So we do not enforce the sale. We leave the property in his hands. Leave the property in the hands of this guy Bar Shatya. And by the way, this only applies. That's only if it was like family property that he inherited, not something that he went out and bought. But if it was not inherited family property, like, there's no chazaka here. There's no way to establish that it was his to begin with. That is, there's a chazaka that it's his, because if you're saying that he's insane, maybe he also bought it when he was insane. So the purchase, when he purchased it, might also be called into question. So then we would have to use the usual rules of evidence and determine, is he sane or not sane, and do we, how do we proceed? Bo says, regarding the idea of, like, is this similar to Eidim Zomim? You can only do Hazama in the presence of the first set of Eidim. But if you're talking about contradicting testimony, that doesn't have to be in the presence of the other witnesses. As we saw before with Rav Nachman. And if you do Hazama, or try to do Hazama not in their presence, okay, so it's not valid as Hazama, but it's still, even if it's not in their presence, it's still, they're still offering contradictory testimony. It would be the same as if they offered testimony that said, we saw different. Not that we saw that you weren't there and able to testify. Okay.
Dov, what's the difference between Hazama and Mach?
And Hakasha. Okay. So the Hazama is a specific case. Hakasha is any kind of of contradictory testimony. Okay. So, I saw, that the car that ran over that pedestrian was a green car, and you say it was a blue car. Right? That's contradictory. But I say this, if I say that Hazama is when I say the car that ran over the pedestrian was a green car, and you say,
yeah. So I got the bulb is out, and can you replace the plastic also?
James, you're
plastic
you're
cover.
Not on mute.
There's a hole in it.
Oh, James, you're not on mute.
You're okay. Just the bulb then.
Oh my God.
Thank you.
Yeah. James, you're not on mute.
Okay, hold on. I'll put it.
Okay. Hazama is if I say I saw that the car was a green car, and you say, wait a minute, you were out of town that day. We were with you in Philadelphia. You couldn't have seen this happen. That's Hazama. It's a very specific type of contradicting witnesses, not directly contradicting their testimony, but contradicting their ability to be present, to have been able to witness something. Okay?
So
now, there's no logical reason why that should be any different. Okay, I'll grant you that. But it is something that the Torah sets out as a rule.
So Hazama contradicting other witnesses, or their ability, whereas Hakasha could be just like, two witnesses testify, or like.
Yeah, they saw different things, or their perception was different.
Two psychologists testifying about the sanity of the defendant. One says he was sane.
Yeah, they have different opinions about what occurred.
Different opinions.
Exactly.
It would be contradictory testimony, but not
correct.
But not like Hazama, which is going
undermining the ability of the witness to testify or to give the testimony that he did. Right, exactly. And again, there's no logical reason, as far as I know, that one should be more believed than the other, but that's the way the rules are laid out. Okay?
Which one is more believed?
Hazama. Hazama, you've got this like special rule that if I come along and I wish there were an English word for this, right? But disqualify your ability to have witnessed what you testified to, then the latter person, or the latter set of witnesses, is believed over the former.
They're always believed?
Assuming that they get checked out like any other witness, right? But yes, they are always believed.
Unless you can prove they're in league with the defendant or something, right?
Yeah, exactly. The usual rules of testimony apply. They have to be cross-examined and found to be credible.
Okay. And then,
Okay,
and then like the third set could be always believed over the second set, and
yeah, exactly. And that's the subject of much discussion in, I think, in Maseches
yeah, yeah,
Makos, which we'll
yeah,
get.
yeah, I remember that. Yeah. Okay, something like
Yeah.
that. Okay. All right.
Okay. Okay. Amar Mar, we said before, if there are witnesses that these are valid signatures, this is, I think, again, the case where the original signers are dead, but somebody says, yes, I recognize their signatures. Um, or there's some other source of independently verifying that these are their signatures. For example, Mishtar Shakar of Ira from another document that had been challenged and had been certified in court, then ein nemanim. Then we don't believe the new witnesses. We can rely on the signatures. So Gemara says, wait, Karl in Lokar lo. You said that the signatures in order to be certified had to be challenged and then certified in court. So Masai Leila Ravasi, that supports Ravasi. Dam Ravasi, he said, and Mekamis the Star, Elamishtar Shakar of Irer, what constitutes the certification of a document or of signatures? It has to be on the signatures have to be on a document that was challenged in court and certified by the court. Now, there's a lot of discussion in the Rishonim whether the Gemara really means to say that the document had to have been challenged. What if a court certified a signature without any challenge, right? So some Rishonim actually say that no, it really has to be through a challenge that the signatures are certified in court, and perhaps because one way to understand this is that the court will be much more diligent in its certification if it is dealing with an actual challenge. But other Rishonim say that the Gemara is not being specific about the challenge. It's just usually the way it happens is usually why would a court certify a document? Because it's being challenged, and then they go ahead and certify it. But even if the court was asked in the absence of any challenge to certify it, then that certification would also be a valid certification and support the idea that these witnesses who are no longer with us had actually signed. Amar Nardai, they said in Narda, how can you certify a signature if you have two ksubas? So you have two instances where the same witness has signed a ksuba, and you compare the signatures and they look the same, then that is a good method of certification. Or it could be two commercial contracts that are signed with the same signatures. And then if that's the case, if that's how you certify something, that's as good a certification as if I had some land and worked the land for 3 years with no challenges, then I have a chazaka that is my land. It's the same, that's a very strong proof or a strong chazaka. The same applies to two matching signatures on two other documents.
So what are we trying to prove here? That the
No, we're not trying to prove. We're saying like what constitutes certification, right? How does the court go about certifying something? Certifying signatures, right? You look at a document and I have Hanan's signature, but somebody says that doesn't look to me like Hanan's signature. So if the court could produce two other documents with Hanan's signature that look the same, then that constitutes.
This assumes I'm not around. I can't validate.
Right, we're talking about right, and the case we're discussing here is when the original signers are no longer with us, have died,
or not around, or unavailable.
Yeah, or it could be overseas, whatever, not available.
So wait, which way is the presumption? Presumption
so that
they're valid, I assume, and that they have to prove that they're not, or something, right?
Right. So as we've seen, like if there's contradictory testimony, then we leave things as they are. We don't enforce the terms of the contract. But if the signatures can be validated and certified, then they count as then it's considered a valid document, and we do enforce it.
So
if there's some dispute over it,
she has to prove that if the wife is trying to get her ketubah, she, and let's say then there were two witnesses, right, on the ketubah.
Hmm. That's a
She
good
has,
question. I don't know if there are separate rules for ketubah.
well, that's a contract.
Um,
I think it's the same with regular contract, isn't it?
yeah, but in the case of the ketubah, like, are we talking about if you're denying that they were ever married?
No, I'm denying that
So,
and I don't want to pay the ketubah, so I'm denying that those signatures are valid or something. I don't know.
right. So in the case of the ketubah, it's very interesting actually. In the case of the ketubah, you can actually, in most cases, collect the ketubah even without the document, because everybody knows that you can't get married without the ketubah.
Oh, really? If you lost the ketubah, you could still get it?
I believe that is the case. It might be subject to some dispute, but I think that's the general rule. Now,
Okay.
exactly how much you collect, maybe you can only collect the minimum or the standard, right? But we all use a standard tuba today. I mean, I have no idea how much 200 pure silver or whatever is actually worth, but that's what I signed, right? But it doesn't matter if I signed it or not, because everybody knows that I wouldn't have been able to get married unless I committed, to the terms of the tuba.
Okay.
Okay, right. But um, but the ketubah itself is still a valid document in the sense that if you've signed the ketubah, and I can prove that that was your signature and it looks the same as this other document signature, right? That's why we're bringing the ketubah just as a sample of a valid document that has not been challenged. That demonstrates, that contains your signature as a sample, as something to compare against.
Okay.
You see what I mean? Okay.
Yeah.
I'm Rashimi Barashi, and Rashimi said, "Ubiyose mitachas yad acher." When can I use this separate document, this ketubah or other commercial contract, to back up, to provide a valid sample of your signature? That's only if somebody else is who's not party to the case, to our case, holds that document. Okay, me not small low, but if you Hanan are trying to enforce a document, or well, okay, if I am trying to enforce a document that has your signature, right, and I also have this other contract in my possession that has your signature, okay, that's no good because you could have forged both. I could have forged both of them, right? So the source of the possession of the comparison document has to be possessed by somebody other than the litigant. Okay. So Gemara says, why? Why do I say that? Because I might be forging both of them, right? So that's why they match. So just because the proof document belongs to somebody else, maybe I saw that document in someone else's possession, and I went home and I forged the signature because I had just seen the signature, so I'm able to forge it. So what's the difference? Like, why are we,
It's kind of
why aren't
hard
we
to do
concerned
that.
about that?
It's
Mars
kind
may
of
say
hard
that.
to copy other
Yeah,
people's signature. It's like I've tried to do that, like, if I have to
yeah,
sign something for my kid and, whatever, and I
yeah.
tried to like, look at his signature, it's really hard.
Exactly. That's exactly the Gemara answer. Is You can't do that, right? You can't do an exact forgery if the other, if you're in your at your desk and the lighting is good and you've got the other signature and you're copying it, that you can do pretty well. But just because you saw somebody else's signature and then you go home and try to forge it, that ain't gonna work. Okay, so that's why we disqualify it if the proof document is in your possession, then you could have forged it easily. But if it's not in your possession, you could not have forged it easily, and that's why it's a good thing.
Okay.
Okay, Tanarama, the rabbi's taught. Kosev Adam Medusa made all of Filu Lachar Kamarshal. This is a separate case, separate principle. I can write, like, let's say I witness something and I take notes. Right, this happens all the time in traffic court. Right, I'm sure none of you have ever gotten a traffic ticket and tried to fight it, but if you did, your case comes up 6 months later, and the officer takes out their notebook and say, on May 22nd, I observed the following. So and so was speeding or talking on a cell phone or whatever. Now, there's no way that they independently remember the details of that 6 months later, but
Right.
we allow them to rely on their notes, and we assume that that is as good as direct memory. Amar Rav Huna says, "V'hu shazarcho me'asmo." That's only if it jogs your memory and you read your notes and you're like, "Oh yeah, that's what happened." But if you don't remember it at all, but you're just relying on your notes, that's not valid testimony. Rabbi Yochanan says, no, the notes are good enough. Even if you totally don't remember it anymore, but you're relying on your notebook, your diary, then that's good enough. That is valid, excuse me, valid testimony. So, yeah, so this is, it's very interesting. I mean, it's there's a whole discussion as to why is this not considered written testimony as opposed to oral testimony. Um, so I don't know the ins and outs of it, but this is Rabbi Yochanan's statement. Amar Rabba, Shmami Oin Rabbi Yochanan. Rabba says we can conclude from Rabbi Yochanan. Hani Beitrei the Yadei Sadusaf. There are two people who know some testimony. Umin Sheichad Minayu, and one of them forgot, and his partner reminds him. Mikar Chad L'Chavre, the other one can remind him. He says, "Oh, they both show up in court, and witness A says, this is what occurred." Witness B says, can't really remember. And witness A reminds him, like, don't you remember we were standing on the street corner and we saw the green car come by and there was a bus on the other side, whatever. He reminds him, then that's okay for one witness to remind the other one. So they asked, okay, so what if the defendant in the case, or one of the litigants reminds him, says like, hey, don't you remember you were standing on the street corner and you saw the green car go by? Is that permitted? Rav Chaviva Amar Afilu Atzmo. Rav Chaviva said yes. Mar Rav Ashi Amar Asmolo. Mar said no. And the answer is no, because you can see the difference, right? The litigant might be embellishing the details and getting the witness to go along with them, whereas the other witness is presumed to be not biased, and just going to report exactly what he saw and remind the other one exactly what he saw. But what if it's if the witness that is forgetful is a rabbinical student? Then we'll rely on him to be meticulous, and even if he's being reminded by the litigant, we still accept that as a reminder. We still accept his testimony that was prompted by this reminder. Like the case of Rav Ashi, that he knew something about Rav Kahana. And he reminded him, he was like, don't you remember what happened? And he said, no. So he reminded him details. Remember, it was like a cloudy day, and we were having lunch at on the picnic bench, and he reminded them of the details. And he still said, I don't remember. Well, Sophie Karavashi, and then in the end he remembered. And he actually testified. And he saw that Rav Kahana was like amazed. What, you think I'm relying on you? I'm not relying on you and your reminders. I actually did remember. I thought about it. Like after you reminded me, I thought, and I excavated it from my memory. So I really did actually remember. So this supports the idea that even though it was the litigant himself, Rav Kahana, who reminded Rav Ashi of his testimony, we still rely on Rav Ashi because he's more reliable than the average guy.
This is called refreshing recollection, which I think is permitted in court, but that's exactly the rule. It has to be, it has to come from the
not.
It can't be
right.
like
That's exactly right. Yes.
Yeah.
Like you have to experience the witness has to experience it as something that he actually now remembers, now that he was reminded, not that he's just parroting what the reminder is telling.
Right, but they're making a distinction between a Talmud Chacham and a regular.
Yeah, actually, it's surprising, right? That we're assuming that a Talmud Chacham will, when he testifies, will only do so if he actually remembers from his own memory after being reminded, and will not just parrot the reminder being given to him by the litigants.
Yeah, that's
Interesting, right? That seems a little specious.
yeah, no, because people have all kinds of motivations and stuff, you know. I mean, okay.
Right. Yeah. Yeah. And there's when it comes to the being reminded by the litigant, it raises a host of other issues. It's not just that the litigant might be leading you down the garden path with his version of events. There could be other things at play, like being threatened or being beholden somehow to the litigant, and being afraid of him. Right? There's a whole other, and I imagine that if that were the case, there's other principles of testimony that would prevent that testimony from being believed. In other words, now it's not just a question of memory; it's also a question of influence. Maybe I don't know exactly, but that's what I agree in principle with what Hanan's saying. I'm not sure how it would play out in the cross-examination process.
Yep.
Okay. Now we're gonna go on to a tangent. So now, Hassan, we have a Mishnah. Hatlulos hakrobos. If you have mounds, bein le'ir bein l'derech, mounds that are located near the city or near the road. Okay, what's a mound? A mound is a place that you suspect might be a burial site. Okay, somebody dies along the way, or somebody dies in town, and for whatever reason couldn't be taken to the cemetery. So could be buried alongside the road, and people would typically use like raised area, raised like little mounds, because nobody is going to take a detour specifically to go up onto a mound, right? You go around it. You want to stay on the flat ground. So people, if they're going to bury somebody and not mark with a poor marking, or a marking that might that might disappear, they're going to do it on a mound. So we suspect that mounds might be tameh, might have dead people buried there. So echad chadashos v'echad yishanos, whether it's new ones or old ones, with a new mound would, you can tell if something has it has recently been excavated or has been built up. So then it doesn't matter, new or old, they're tameh harachokos. But if it's further from the town or the path, then chadashos taharos. If it's new, then it's tahor. And because presumably people, it's like in living memory of, like, people will remember that someone was buried here. But if it's old and it's near the path, then it would be tameh. We have to assume that perhaps somebody was buried here a long time ago and nobody remembers. Ezu krova, what does near mean? Near the road or near the town? 50 amos. Ezu yeshana, what does old mean? Shishim shana, 60 years. Anything within 60 years, people would, it's like within living memory that somebody might have been buried there. Romero says, Romero, krova she'en krova hema. Near means the nearest, right? There's no closer one. Yeshana she'en adam sofra, and old, there's no like 60-year rule. It's just that nobody around here would remember it anymore. Okay. My derech, and what is the definition of town or road? Ilema ir mamash derech derech mamash, if you mean like literally a city or a road. Misfeka mimachzikina tuma. Like you're going to say that 50 amos near any city can be considered tameh, but we don't do that. Rish Lakish says, we actually use any kind of legal gymnastics to make places in the land of Israel, to make them tahor, right? So don't give me this idea that there's a blanket way to say that a place in Eretz Yisrael might be tameh. It's the opposite. We go out of our way to find ways to make it tahor. So what are we talking about here? Amar Zer says here, hasmucha al-beis hakvaros. We're not talking about any city. We're talking about a town that's near a graveyard, right? A cemetery. The derech beis hakvaros. So the road means a road leading to the cemetery. There you have more of a reason, like a real reason to be concerned that there might be something or somebody buried there. So Gemara says, okay, I understand. I understand the road to the cemetery. People might be buried alongside that. Maybe, the funeral is late. It's Friday afternoon and you got delayed for whatever reason. And all of a sudden you realize the sun's setting. We haven't gotten to the cemetery yet. So we better bury the guy right on the side of the road so we can get home in time for Shabbos. So that's, and umikru kavru betel. So therefore you wouldn't go all the way to the cemetery. You're in a hurry. So you would bury the person on the mound by the side of this road. Right, and that would only apply on the road that's leading to the cemetery. But what do you mean by a city that's near a cemetery? Everybody goes to the cemetery. Like, why would you think that a random place near the town would contain a dead body and somebody would be buried there? What if somebody were, trying to keep something secret, like a woman who's burying a miscarried baby? So she wouldn't go to the cemetery because people would see her going to the cemetery and conclude that she had a miscarriage and she wants to cover it up. So she would go to a random place near the city. And that's also where people, if you lose a limb because of whatever ailment, that limb is also tummy. So, I don't know, people are embarrassed or don't want to go to the cemetery with their severed limb. So they would go to a random place. That's why you have to be concerned that mounds near a city could be tummy. And why near the city? Like, why couldn't that be just, say, anywhere that might be the case? So a woman would only go 50 amos away from out of town. If it's more than 50 amos away from the city, so presumably, I don't know, I guess she would be afraid to venture out by herself. Then what she would do, she would recruit a relative, a male relative, and go so that nobody would suspect that they're going to bury a miscarriage. I don't know. That's I don't really get the logic there, but I don't really understand what the Gemara's assumption is about women wanting to bury their fetus in private. So Hilkach Tuma Beretz Yisrael Machzikina. Therefore, we don't make an assumption about Tuma in Eretz Yisrael if it's more than 50 amos from the town. We can conclude from Rav Meir, that how long is memory? 60 years, because we said before, like how old is an old memory, or an old mound? If it's more than 60 years old, so that means that people remember things, or things can be remembered for up to 60 years, but not longer than that. So the Gemara is concluding that if I testify to something that happened more than 60 years ago, that's not valid. But that's not the case. Below he, Gemara says it's not the way we rule. If it's, if I see an incident that I will later testify to, right? If I see a bank robbery, or I see a hit and run, right? Then that's something that I understand is a thing that I should testify about, right? And I will remember it. But sorry, the other way around, right? So if I see an incident, then I can remember it for more than 60 years. But if I see, if I see a funeral taking place on a hill, that's not something that I think I'm going to be called on to testify about later. And so more than 60 years later, I can't be relied on to discuss that. And I guess we'll leave it here for today. Start the new Mishnah tomorrow.
So what was the connection between this Baita about burial hills?
Oh, yeah, it has to do with, it's very tangential. It just has to do with with testifying about, yeah, I mean, I don't even know what the oldness is.
It has to do with memory, how long witnesses could remember something.
Right.
Yeah, but we haven't been discussing how long witnesses can be remembering something, right? It was totally tangential topic, I guess.
No, we were
I don't have
talking
an
about
answer for that.
witnesses who remind each other of something that happened.
Oh, who remind each other. Yeah, that's true. Yeah. Okay.
Right.
You buy that, Hanan? I buy that.
Yeah, sure. Why not?
Okay. Thank you, James. Okay, everybody. I'm going to be away for like 3 weeks. So David, I think, will be covering. And I'm back August 18th. So pick it up from then. See you all then.
Job, are you open to doing it in person when you get back?
Yes, I am open to doing it in person when I get back.
Okay.
And so I expect we'll start that. But somebody has to remind me.
Well, hopefully it won't be 60 years.
Right. Okay. All right. Have a good
Great
day,
day.
everybody.
Thank you.